Good morning, everyone, and welcome to a fantastic MBALT webinar with Kaiser Mason Ball. Today's webinar is on letters of intent, so it should be a fantastic event today. So I'm just going to take this sound away. Today we have presenting with us is Ian and Ted, both from Ian is a partner with Kaiser Mason Ball, and Ted is on council with Kaiser Mason Ball. So again, thank you to KMB Law for hosting this event today. I'm going to hand it over to both our presenters this morning, and we will get started. Over to you both.
Good morning, everybody, and thank you for joining us. On behalf of Ted and myself, we're glad that you took time out of your day to spend a little time with us, and hopefully we can ensure that that time is valuable for you. The discussion topic today is letters of intent and some tips and traps in relation to both their use in business acquisition, but also some of the recent experience around letters of intent and litigation, to be blunt, with regards to the use of letters of intent, how to avoid it, how to use them effectively, and to ensure that whether you're buying or you're selling, you don't run into any of those dispute type problems. And we're going to go through a couple of steps today. The first one will involve me talking a little bit about letters of intent, their purpose, and the functions they serve for both the buyer and seller. And then Ted's going to talk again a little bit just about some of the recent challenges or perspectives that disputes in courts have taken with regards to letters of intent. And then he and I will do a little brainstorming around some of the things that we do and some of the things we've seen to help to minimize those issues, followed by questions, concerns, thoughts from you that we will do our best to handle. So let me start off with sort of the purpose, basics of letters of intent. And just to clarify, we're talking about letters of intent in relation to business acquisition, business divestiture, or business investment. Letters of intent can be used in lots of different commercial categories, but we're focusing on that. And your typical letter of intent, why do you have it? Why do you even need one? It's part of the process in business negotiation. It's not typically the beginning of the process, by the way, but it's pretty close. There's usually been some discussions. There may have been some marketing of the business for sale. There may have been confidential information memorandum prepared and circulated. There may even have been a confidentiality agreement entered into to let people get a little more information and spread a little more information about the business. The letter of intent steps in fairly early in the process, usually not at the beginning, but fairly early. And what does it do? It forms the backbone with regards to key terms to move forward and see if it's worthwhile for the parties involved to go on to the next step, which is usually due diligence, ongoing negotiation, and negotiation of the purchase agreement. The letter of intent, I like to refer to any transaction and tie it into a very similar social process, and that's the human process around dating, engagement, marriage, and whatever comes after marriage, sometimes good, sometimes bad. And the letter of intent fits right into that. The only problem is that the chronology is different. We're used to traditional forms. Typically people meet, maybe date, maybe get engaged, then get married. That's what we think of it. Well, in business terms, that's not actually completely how it works. The letter of intent is the part that sort of comes at the beginning. Signing a letter of intent and getting to the letter of intent is usually the dating phase. That's when a seller is being wooed by a purchaser because the purchaser really wants the seller to sign that letter of intent. So that's the magic time of wine and roses. Once the letter of intent is signed, marriage is not the next step. If that's the engagement, that's not the next step. The next step in due diligence is actually when the purchaser will be investigating the business, not only to firm up their perception, but to be blunt, to look if there are things that they can use to attack purchase price and terms. And that phase actually comes before the marriage, the transaction phase. And it's important to remember because As a seller, what that means for you is your best time to negotiate, get terms, get commitments is actually prior to the execution of the letter of intent. That is your best bet. And of course, if you're a purchaser, what you're trying to do in many cases is limit those good promises that you have to get in order to get a letter of intent signed. Now, what purpose does a letter of intent serve? It's different for the two sides, generally speaking. Most purchasers want a very short letter of intent. They want a letter of intent that serves only a couple of purposes. The primary purpose, many of you may know, but for those of you who don't, from a purchaser's perspective, primary purpose of the letter of intent is to get a commitment to an exclusivity period. That's what a purchaser is looking for. The purchaser in the perfect world would like to have a letter of intent that does not commit to any terms, no purchase price, no payment terms, nothing in the perfect world. Let all of that be determined in due diligence because they will use information they find to be able to attack what a seller might think is fair or appropriate for the business. So a purchaser is looking for that exclusivity period, the promise that you as a seller or that the seller will not deal with anyone else for a specific period of time. And many people aren't aware, most exclusivity periods actually include a further provision. And that provision says not only will you not deal with anyone else, but if you are solicited, if any other opportunity comes to you, anyone else approaches you, you're obligated to provide that opportunity on to the purchaser. And you say, why? Why do you have to do that? Well, theoretically, under an exclusivity period, it could be possible for a purchaser to have you commit to the exclusivity period. Another purchaser arrives and is willing to pay more. Purchaser A finishes the deal with you, and because you were obligated to provide on the new proposal, purchaser A buys from you and decides it's better to just flip the business immediately and sell it to purchaser B and pockets the profit. Okay, so it's very important for you to understand if you're selling what a purchaser is after. And of course, from a purchaser perspective, that's what they're looking for. Minimize any sort of obligations. They want to include in there as well, very clearly, the obligations of the seller to provide due diligence access. They want to limit any sort of restrictions on that. And a purchaser wants to include as many conditions as possible for them to be able to get out. That's what a purchaser is looking for. Seller, much different. Your typical seller, if they get the letter of intent that they really wish, it will serve as a roadmap for the transaction. Everything of importance will be in there and will have been agreed upon. And I go back to my first point. The wooing period is before the letter of intent. Therefore, the best time for a seller to get what a seller wants is in the letter of intent. Purchase price, payment terms, security of whatever type they require. If there's going to be some deposit terms, I saw someone ask questions that usually have a deposit in agreement. If you're expecting a deposit, you're going to want to talk about it in that letter of intent. If you're, as a seller, expecting that deposit to be in part non-refundable or to become non-refundable if certain events occur, you're going to want it to be in that letter of intent. And as an aside, and answer that question, for the last couple of years, it's been a seller's market. And what does that mean? It means that deposits are once again fairly common in letters of intent, including in certain circumstances, all are part of the deposit being non-refundable. Again, more common just because of the pressure on purchasers to be able to find and compete over transactions. And in addition, there's going to be clear language about the fact that there are methods that the exclusivity period can be terminated. It's still going to probably have an exclusivity period. A seller's going to want it to be limited, very specific. The seller's going to want to have the ability to terminate that exclusivity period early in the event certain things occur or do not occur. For instance, the due diligence period is likely to be limited if the seller gets their way and the purchaser either has to agree it's completed or the seller has the right to get out and has the right to limit exclusivity. These are all the types of things that a seller is going to want in that letter of intent. And this brings my last point in discussing letters of intent as an understanding, which is people talk about non-binding letters of intent. The truth is most letters of intent do have binding provisions in them. Letter of intent is typically composed of three parts. A non-binding provision, which might very well be, we're interested in buying your company. Here's the purchase price we're thinking of. Here are the payment terms. Non-binding, morally hard to move off of without a reason, but non-binding. Then there's going to be a binding section that deals only with the period of time when the letter of intent is effective. You promise to cooperate in providing us with due diligence. You promise to provide us access, seller. Those types of things. There'll be binding provisions that only last as long as the letter of intent does. And then there are likely going to be binding provisions in the letter of intent that survive, which includes, as an example, any information that's provided will be kept confidential by the purchaser, including kept confidential after the time that the letter of intent is terminated, if it is. So there's a little bit of your framework. I know that's about 1,000 words a minute, but gives you an idea of buyer side, seller side, their interests, which are very divergent, and also the three basic parts of a letter of intent, which includes, as I pointed out, binding provisions. And now I will turn over to Ted for a little while.
Good morning. Many letters of intent, I dare say most, will contain a provision that the negotiations are to be carried out in good faith. And that can lead to litigation. So if you're the vendor of a business, if you're bringing in partners, and the negotiations break down, you may find yourself in a lawsuit which ties up your business for an indefinite period of time. So let's look at a story, and we'll use Ian's courtship theme. So you own a business and you have a reason to sell it. And let's say there's some urgency. Let's say you want the proceeds to give to your children to open a restaurant, or doesn't really matter. You owe money and you're wondering what the lender means when it says, I know where you live. It doesn't really matter. So you enter into an agreement, you enter into a letter of intent, and you begin negotiations. And along the way, you determine that perhaps you really don't like the prospective purchaser. Perhaps there will be a continuing relationship in the nature of, for instance, an earnout. There may be material terms that you can't agree on. You may have, for instance, a non-compete clause that you do not achieve a consensus about. So you want to let the letter of intent to expire, and you want to go ahead and sell the property, to sell the business to a different entity. And so you let the prospective purchaser know this, and the prospective purchaser says, no, you haven't negotiated in good faith. They sue you, and they ask for something called specific performance of a contract. So when you sue somebody, you can ask for damages, or in the alternative, you can ask that the contract be performed fully. So your argument as vendor is, well, there's nothing to perform here because we didn't achieve a contract. But what will happen in those circumstances is you'll be tied up in court for months and perhaps years. If you try to sell the business to somebody else in the interim, nobody will purchase the business because there's a pending lawsuit where the vendor may no longer own the business. So one has to be very careful about that. This has become an issue fairly recently. Some years ago, the Supreme Court of Canada said there's a duty of good faith in the performance of a contract. So among other things, you can't lie. The Supreme Court waded in on the issue again in a recent case called Callow. This was a couple of years ago, and in that case, a condominium group negotiated for the services of a maintenance company, and there was both a winter and a summer contract. And there was an expectation that the condominium company would not terminate either one of those contracts. What happened was that I'll read you an email that was sent by the condominium company internally. The maintenance company did additional work to incentivize the condominium company to continue its contract. And the internal memo said, "It's nice he's doing it, but I'm sure it's an attempt at us keeping him. By the way, I was talking to him last week, and he is under the impression we're keeping him for winter again. I didn't say a word because I don't want to get involved, but I did tell Tammy that Calvo thinks we're keeping him for winter." The Supreme Court didn't like that, and they said that there was a breach of duty by knowingly misleading Calvo into believing the winter maintenance agreement would not be terminated. So this plays into what I'm talking about, which is there's a duty now, not only in the performance of a contract, but in terms of the termination of a contract, not to mislead. So we have a dynamic with letters of intent, which is, on the one hand, they're not binding. On the other, there's always an opportunity for an unwanted suitor to hold you up in litigation for a great period of time.
One of the challenges that we have is that in the last few years, the market for people selling businesses has been very hot. And that creates challenges for us as legal counsel if we're representing sellers. It also creates suspicion if we're legal counsel representing purchasers. And what do I mean by that? Is you have a client that enters into a letter of intent to sell, and it's worked through at least some of the terms of the deal. And they're going through the due diligence. And let's say the due diligence period with the target closing is a total of 90 days. And somewhere around day 45, your client calls you and says, "You know what, I'm not very happy. I'm not happy with how this is going. I think it's taking too long. I've given a lot of thought to the purchase price. I think the purchase price is too low. I think I can do better out there. As a matter of fact, I already know my company's worth more than what they're offering." Now, if I'm hearing that as legal counsel to the seller, one of the first things that pops into my mind is, well, how do you know? And the answer in today's market, the last few years, is they know because they have been approached repeatedly, perhaps by other people interested in buying the business, or at the least by brokers in that time period who've said, "Hey, do you want to sell your business?" And this is especially true with entrepreneurs. Their approach is, "Well, yeah, let me hear what you have to say." Now, by going through that process, they've already probably breached the terms of their letter of intent, which just specifically says you're not allowed to talk to anybody in the exclusivity provision. And by the way, if anybody approaches you, then you have got to refer them on, neither of which they've done. And usually what I hear is, "Well, you know, all they did was call, and I didn't push it any further. I didn't give them any information." All right? But clearly something's in the mind. And that has been a great challenge because purchasers are aware of the market as well. So when a transaction or a possible transaction goes south during the letter of intent period, they are asking themselves why. And in this marketplace, they're increasingly suspicious that the reason it's gone south is because there's been a breach of the exclusivity provision, right? And because of that, we have two things. We have vendors who want to get out of a letter of intent because they think they can get more, probably because they have breached the provision. And we have purchasers that are trying to buy businesses, competing to buy businesses, who suspect that the reason a vendor is getting out is because they have breached the provision. This has put extra pressure on the concept of litigation. And what I try to tell clients is there are at least two ways in which letters of intent situations are problematic. One is the wording of the letter of intent. And courts have very much looked at the wording and said, you know, this letter of intent includes wording that sounds like it's binding. It has areas that talk about words like agreement, talk about situations such as shall do, will do, talks about acceptance or upon acceptance. It has language that's confusing to the court. It says it's non-binding, remembering what I said originally, most of them have binding provisions, right? And then it's got binding language, including binding language, perhaps, in the part they said was non-binding. This leaves a court with some wiggle room. It also leaves a purchaser with leverage to be able to say, hey, you know what? You had an obligation here. So if you don't do a deal with us, we're going to have a problem. So there's the actual wording. In addition, though, is a second problem, and that is conduct. You know, the agreement, it's like people always say, Ian, I don't want this person to be an employee. So let's title their agreement independent contractor. And I'm sure as all of you know, the answer is you can call it whatever you want. The court looks at the words and the court looks at conduct. They do the same for letter of intent. So they say, all right, you got this nice document. What did you do? There's a famous court case that held that there was a binding agreement reached. There was nothing ever signed other than a letter of intent. But the court said, yes, right after the letter of intent was signed, the seller had a meeting with his employees and announced that he was selling the corporation and was retiring. They started to reach out and let customers, big customers, know that there had been a change in ownership. The court said, listen, the conduct says this deal was binding, it was intended to be binding. Both sides acted as if it was. So that's a real problem in dealing with letters of intent. You have to make sure the language is very clear to avoid problems, and you have to make sure the conduct is consistent. And that's a tough line, because the closer you get to the finish line of an agreement and having that agreement implemented, the more the conduct lines up with you having a deal. Namely, you start to talk to employees, you start to talk to key employers. So it is tough to manage, and it's something that you have to turn your mind to. Then there's one other thing I'd like to throw in. As business lawyers, you know, I always say, you know, for us, rightly or wrongly, Canada is made up of two parts. It's made up of Quebec and all of the other areas. And the reason we say that is because the legal system in Quebec is not based on the same common law system where all the other ones are. Quebec has a civil code. It's based on the Napoleonic Code. It's different. Well, guess what? Quebec is different around letters of intent. Quebec, if Ontario is fuzzy about whether or not there's a duty of good faith outside of having a binding agreement, Quebec is not fuzzy. In the Quebec Civil Code, there's an obligation to act with good faith when any obligation occurs, not just when there's an agreement. And that applies to letters of intent. And the reason I say that is because you have to look at some of the circumstances around the letters of intent. One that I'm looking at right now is I have a client that is selling. The purchaser is based in Quebec. They produced a letter of intent. That letter of intent is to be governed by the laws of Quebec. And the answer is we're not going to agree to that. And the reason we're not going to agree is because that brings in this concept of good faith right into the letter of intent. So little legal issue, a hiccup for us lawyers, but something to keep in mind in your letters of intent that you have to care about who it is you're dealing with, where they're located, and what law applies. Because while in Canada many of the jurisdictions are the same, Quebec is not. That's a challenge. That's a challenge that can be used by guys like Ted to be able to tie up a business in the event that there's a letter of intent that's gone sideways.
The Cano case originated in Quebec. That's where it started, and it ended up in the Supreme Court. So the issue is often like this. Proposition number one, a court will not create a contract. The court will never say, well, this is what the agreement should be. However, the court can, for instance, look at a draft agreement and make a finding that, well, you know, we don't have any commentary about this draft agreement, but it looks as if the parties are already performing it. And so the court can make a finding that the draft agreement is essentially a memorialization of an oral agreement that has been reached by the parties. So the issue for me, generally, if I'm in a court about this kind of thing, is how close are we to an agreement? Have we reached consensus on all material terms? What is a material term? If you're down to, well, is somebody going to be an independent contractor or an employee? Is that material? Or what if there's been an agreement on price, on closing dates, on a shareholders agreement? Is that close enough? The area is something that is quite fraught, and I think with in the coming years, a whole bunch of litigation may arise out of this, I would call it uncertainty.
So if you're looking at the letter of intent issue, what at the end of the day are we saying you should do or not do? Let's take the purchaser side first. If you're a purchaser, I think there's a couple of things that are very clear. One is, I would like my letter of intent to be as short on details in many ways as possible. What do I care about? I care about having a long exclusivity period that definitely includes an obligation to refer to me any other opportunities that arise or proposals or solicitations that come in. I also, as a purchaser, want to have some very clear conditions that allow me to walk out if I'm not satisfied, whether those are due diligence, financing terms that I'm satisfied with, key customer approval, whatever it is, and preferably more than one that allows me very clearly to walk. I probably have to concede if I want to fall into the second camp, which is possibly have a letter of intent that I could enforce. If I want to go down that route, I probably have to have some material terms in there, purchase price, payment terms. I probably do. Combined with a liberal sprinkling of language that makes it sound like it is more of an obligation and possibly binding. Use of mandatory words, shall, will, must, use of agreement and acceptance sprinkled throughout. That is if I want to be in a position or I am concerned that there is enough competition out there that the vendor might get cold feet. So clearly exclusivity, clearly conditions that allow me out, and possibly combined with some key business terms to be able to find a contract and some mandatory agreement style language if I am concerned and want to enforce.
Would there be circumstances in which you tell your client, either a purchaser or a vendor client, we're not agreeing to a good faith provision in the letter of intent?
So if I am, so let's stick with the purchaser side. If I am on the potential purchaser side, I probably want good faith language in there, all right? And a lot of it comes down to trust. So that bit about sprinkling in some language that sounds like good faith, lots of obligation type wording, that might very well come out of a discussion with the purchaser where I would say, listen, the vendor, do you trust them? To be blunt, do you feel that they're going down this path and they're pretty committed, or are you worried that they're the type of person that if someone came along and said they have a better offer, that they would switch horses in midstream? And to the greater extent that a purchaser has concern that way around trust, then probably the more you're going to sprinkle in those types of words, and maybe if you think you can get away with it, include a good faith obligation.
If you're acting for a vendor, and why wouldn't you just say to the purchaser, look, we'll give you 90 days. We will give you all of the due diligence documents that you want, but we're not making any promises.
So usually the exclusivity commitment is a trade. The vendor is giving that up in return for the purchaser saying we're willing to go down this road. So the usual argument that you will hear from a purchaser is, if I'm going to do all of this, including due diligence, I'm going to spend a bunch of money. I'm going to spend a bunch of money on professional advisors, lawyers who are going to draft stuff up. I'm going to spend even more money at this phase on my accountants and personnel to come in and do the due diligence. And I'm not going to do that unless I have some sort of commitment from you that while I'm doing that, you're not out there shopping around, at least in part because some of what I do in the due diligence and raise with you can help you, vendor, to better understand your position in the marketplace and be more informed in soliciting other offers. So it's hard to get a purchaser, even in this market, which is a very competitive market amongst purchasers to try and buy. Even in this market, it's hard to get a purchaser to commit the time, effort, and money to pushing a transaction down the field without giving up a period of exclusivity. However, what we find is a lot more pushback from vendors on the length of the exclusivity period because their response is, there's other fish in the sea, and I don't want to be tied to you too long. So, I'm not going to give you a 180-day exclusivity period. What I might give you is 90, maybe even 60. So the period is shorter. In addition, sellers will usually be pushing to say, if I've given you 90 days, let's say, of an exclusivity period, by day 45, a purchaser will have had to give me notice that you have completed your due diligence and you've waived the due diligence condition, and that's gone. So I'm going to start to cut away some of the reasons why you might be able to walk away at the last minute. So you're seeing sellers are still giving exclusivity periods, but what you're seeing is more pressure to shorten them, more pressure to condition them, and allow them to be exited early on the vendor side.
Isn't it, the quid pro quo is this: we'll take our business off the market for 90 days or 180 days, and and that's what we're giving you. So you pay for your experts. We're not promising anything.
Yep.
And certainly in a hot market, you may be able to impress upon a purchaser that you're giving up enough without that provision of good faith.
And vendors are definitely trading the exclusivity, which is the vendor's way of showing they are committed and serious to a purchaser. They are definitely trading that for a deposit as their way of requiring the purchaser to show that they are serious and committed. And sometimes, it's like anything else. If you're popular enough, then you get to dictate your conditions. So if you have a business that is very desirable and there's lots of opportunities for people to acquire, then not only are you asking for deposit, you may be asking for certain parts of that deposit to be non-refundable because you're going to be engaging your own lawyer and your own accountants on your side to answer questions, and you don't want to be out of pocket. So we're also seeing that as part of that trade on the exclusivity side, and that's very common. Now, the challenge you have is that to answer to the seller's concerns means spending a lot more time on the letter of intent and negotiating the letter of intent. If you're going to talk about some of these terms, and we typically, if we're talking on the seller side, we want purchase price, payment terms, security, of course. We also want the non-compete and the basic terms of the non-compete discussed in the letter of intent, of course. We also want liability discussed around representations and warranties. We want caps on liability. We want a threshold before it gets triggered, which might be a deductible. We want a lot of different things around liability exposure, and that's in the letter of intent. That's where the seller is forcing the money to be spent, and that's what a purchaser is trying to push against because they don't want it. But this is the time to get these things. All of those terms I just mentioned, they're in the non-binding part of the letter of intent, but it is a moral commitment that is hard for a purchaser to get away from. If the purchaser says, as an example, I'm going to pay you $7 million for your business, you'll get 5 of it on closing, the other payable over 2 years, It will be guaranteed by security over the company, and my main operating company will also give you a guarantee. And if they say about the reps and warranties, you know what? We're going to cap liability at 50%, any reps and warranties. It won't be, the survival period will only be 18 months. We can't chase you for the general reps more than 18 months later. If we say that, you know what, we want this company badly, so there's a threshold. You know, you don't have, and no claim can be made against you until the claims are more than 350 grand in value. Like, all of those are great terms. You will have great difficulty getting those from a purchaser when you're in the exclusivity period. But to get you to sign the letter of intent, the purchaser might be willing, and in fact, in many cases, is willing to give that. So you get it there. You get it there, and that's where the money is spent. But then you've got all the terms of the purchase agreement. Most of the contentious terms are set. You know, if you're worried about your working capital, or if you say, I want to make sure that they give me credit for my inventory, even though my inventory is old. Say, you know, when do you negotiate that? When do you put that in? The answer is the letter of intent, because they want that exclusivity period badly enough. They'll agree to that term in there. Later on, you know, if it's not in there, if you try and negotiate it into the purchase agreement, it's much more challenging. And that's why, as a seller, you know, the letter of intent, you want it to cover as much as possible. And if you're the purchaser, you want all of those terms of the greatest extent possible. You want them pushed on to the negotiation of the agreement. You don't want them in the letter of intent.
It's curious. This is why this becomes a bit different than courtship and dating, which is, I can't imagine a relationship working out where somebody is dictating all of the terms on the first date, which is what I think you're talking about here.
Yes, but the you know, the thing most people have to remember if you're selling is if you're selling your business, you're negotiating not the beginning of a relationship, you're negotiating the end of it. That's how it works. And to tie all that back to this, if I'm a seller, I want very clear exit provisions. So I want to make it very clear that I can terminate this letter of intent, which includes the exclusivity period, and I want it very clear that that can end with no strings. Again, back to this, you know, the fear that people are running into now is that it doesn't work out. There is no binding agreement, but because of litigation threatened around the letter of intent, that seller can't go back to the market. And they are forced, they don't have any choice now, they're forced to sort of deal with one way or the other the purchaser. So you put all of this in, you hash these out to avoid misunderstandings later, and then if the conduct of the purchaser in negotiations later doesn't match what's in the letter of intent, you want nice, clear, cutting edge exit provisions to get me out, no strings attached, so that I can move on to the next possible transaction.
In some of this litigation, the purchaser will litigate perhaps not because it thinks it can win, but rather because it believes that by litigating and holding up the business for a substantial period of time, that it will force the vendor back into the deal.
Yeah, by definition, the purchaser knows that the seller is trying to sell. That's what generated this in the beginning. So if there's not a deal with that potential purchaser, they're assuming there will be a deal with someone else. That also means that there will presumably be a pot of money. There is the pot of gold at the end of the rainbow. And so that's the challenge with this type of litigation, that the purchaser has really two options. It can either end up having the transaction come back on the rails. Okay, but there's another option. The other option is that transaction is gone, but in the future sale, it just takes a part of the profits. It gets compensated or settles out of that.
Just in terms of timelines, if there is no merit whatsoever to the purchaser's claim for specific performance, it will nonetheless take 6 months to a year to have that issue resolved by way of a summary judgment motion. So to get to that point, there will be affidavits, there'll be cross-examinations on those affidavits. You'll spend a great deal of money on your litigation lawyers. A good estimate might be $100,000 to get to a summary judgment motion. If you fail in the summary judgment motion, then it'll take years before you will get to trial. So your business will be tied up for that long a period of time.
It's for a commercial guy like me, it's a very frustrating situation. Now we've sort of run through some basics of letters of intent. We've talked about some of the challenges that are present. We've also talked about some of the perspectives on how, as a purchaser, you might take advantage of this concern, and as a seller, you might try and minimize it. However, we're happy to answer any questions or deal with sort of any sort of issues on the topic that might come from you. We certainly appreciate you listening. So if you have any questions or comments that you'd like us to address, just let us know, and we'll take those now.
Great. Thank you, Ted and Ian. It's always a pleasure to have both of you on here. So much information. So thank you. Thank you for joining us. I did see some questions here, so I will ask that. I've been typing it in. If anyone has any questions, you can enter your questions in the chat, or if you prefer, you want to raise your hand and unmute yourself and ask Ted or Ian or both a question, more than welcome to. So we do have a question that came in earlier. Is it common for the seller to ask for a deposit in the LOI document?
As I mentioned earlier, like, to me, it is. This is just a question of leverage, bargaining power, and I think that because of the market over the last few years, it has more common to see deposits paid because there's more competition amongst purchasers for businesses. So the answer is yes. People always talk about what's the rule of thumb, and that is much more challenging to provide a rule of thumb because it really is situation specific. Sometimes they are based on a percentage of the purchase price. And then if that's, that covers part of the field, and that might be a small percentage of the purchase price. But the other one that commonly comes up is for the deposit to somehow be commensurate to the expense the vendor expects to bear. And some of that expense might be non-monetary. In other words, the value of the people being involved in the due diligence process. So we see that, and those types of deposits, when you're talking about expense, much more likely to be like a $25,000 to $50,000 deposit. If it's based on a percentage of the purchase price, that can be anywhere from 1% to 5% of the purchase price, and it varies pretty widely within that range, depending on how much leverage each of the party has.
What I would add to that is that a letter of intent is not some store-bought document. It's a document for which you're going to need legal advice. It's going to have to be thoughtfully thought through, and an experienced lawyer can save you a lot of heartache at the end of the day. So what Ian has spoken about today has been an education for me, and it just underscores the value of good counsel right from the beginning. So do not make the mistake of saying to yourself, well, it's just a letter of intent.
I as a lawyer, I love long and complex letters of intent because they're the roadmap for the deal. It makes it very easy to draft the purchase agreement. It also avoids a lot of conflict or difficulty in the purchase agreement between the sides. Now, if I'm a purchaser's counsel, maybe I don't like that as much from a positional point of view, but for just making sure people have reached an agreement, it makes it a lot easier. I also think, sometimes people want to avoid the tough conversations. And I always like to tell sellers in particular, there is no incentive for you as a seller to avoid the tough conversation, because the tough conversation will only get tougher after the letter of intent. Now, if you're a purchaser, then the answer is yes, avoid the tough conversations as long as possible, because the closer you get to a target date, the more likely you as a purchaser are to have a successful outcome on the tough conversation. But that's the two sides. I'll give you a perfect example. Most sellers, if they have an earnout provision, which are always a headache, I like to tell them, negotiate the earnout provision, work through the earnout terms right in the LOI, because if you can't agree on them in the LOI, you will never agree on them in the purchase agreement. So, but again, that's just the two sides.
So in a current piece of litigation, the parties can't agree how the earnout is going to work. Is it based on earnings or is it based on revenue? And so it's being hotly litigated as to whether this is a material term that couldn't be agreed upon, thus ending the relationship between the parties. So a well-drafted letter of intent will deal with these issues right from the outset. On an earnout, there are very different considerations for the vendor and the purchaser. So the considerations are real, and something like that is a conversation that is well had right at the beginning. And again, I would agree with Ian that you better address these hard questions right at the beginning. Because in the case that I have, it's become impossible to handle those issues now.
Now, Stephanie, do we have, I think I keep seeing some other questions.
Yep, we have a few others. Yep, we do have a few
Screen.
others. So, should sellers' purchases accept LOIs drafted by brokers or salespeople? And also, when is it a good time to involve a lawyer, pre-LOI or post?
I think I know the answer to that. I say pre-LOI and don't let the broker draft the LOI.
Yeah, I mean, I'm a little bit biased on broker LOIs, and the reason is most, not all, but most of them, especially on the smaller transactions, when you read the broker's LOI, the primary purpose of the LOI is to get a closed transaction. And so many of the points that might be points of contention, what might be issues that need to be resolved are often not included. And also sometimes the letter of intent from a broker will say, you know what, if a deal isn't closed, you still owe the broker a commission. So generally speaking, I say, listen, if the broker drafted the LOI, you still better get it reviewed and do not sign it in its current state. To Ted's point, absolutely it should be pre-LOI. I always like to tell people, if you bring me in post-LOI, I don't mind it, because what it means is you've already given everything away. Like all the mistakes have already been made, and none of them were made by me. So it makes my job easy. I get to point out the mistakes, but bear no liability for them. None of them are my fault. So generally speaking, it's pre-LOI. The LOI for a guy like me, it should involve clarity and completeness, which means a lot of the key terms are in there. And to make sure they're covered, it should be addressed by your lawyer ahead of time. And that's particularly true with the seller, because most people that sell a business, they've never done it before. Most clients have never done it before. So, you're talking about signing sort of the keystone document that indicates the terms around a transaction with which you have no familiarity. It's not at all like, for most clients who are selling, it's not at all like what they do in their daily business, even if they think it is.
Thank you.
Yes, well said. And I don't care if it's the broker or the lawyer, or I don't care who screws it up, as long as it's screwed up, because then I have work to do in mitigating it.
Now, do we have other questions on the?
We do. We have two more. We have time for two more questions. So in the States, we never see binding LOIs, but we do encounter those in the Canada-US border deal. Do you see binding LOIs in Canada? Are Canadian parties more comfortable with?
So I would answer this question with a little bit of explanation. So I rarely see letters of intent that are fully binding. As a matter of fact, I don't think I've ever seen a letter of intent that was completely binding. If it was, it became something else, became a letter agreement. However, we regularly see letters of intent that have binding sections. As I mentioned, it's often made up by 3 different parts, clearly stated as non-binding, binding, during the term, the existence of the LOI, and then binding both during the term and after. And that is very common up here. So we regularly see letters of intent that while the entire letter of intent is not a binding document, sections of it are. And that's very common on our side of the border. And it would be, I would argue that up here, north of the border, that's the common practice, is that the letter of intent includes certain sections that are binding.
Those certain sections include, I would take it, the due diligence provisions, confidentiality provisions.
Termination provision, quite likely a dispute resolution mechanism, which would be included in the binding mechanism. Probably the exit mechanism would be binding. So there would be a number of different sections that are included as binding, either binding during the term or post, very common. And that would be, the standard approach in Canada.
Great, thank you. And we have one last question. If parties do not agree on a purchase agreement by the stated date on the LOI, is it common to amend the LOI, or does a new LOI need to be redrafted?
The most common approach is assuming they haven't reached an agreement, but they still want to continue to negotiate. So the 2 parties are still interested in reaching an agreement, and they haven't met the date. Then the most common is to amend the LOI. It might be done literally by a 1-page letter that simply amends the LOI that says, you know what, there was a drop dead date of X. We both agree that that drop dead date has now been replaced and is now, as opposed to a drop dead date of April 30th, the drop dead date is now June 30th or May 30th. And so it's most common to do it by way of an amendment. You wouldn't replace the LOI in those situations typically, unless there had been other material changes in its terms, right? So if you went back and said, I'll give you a perfect example, as opposed to the purchase agreement, something has happened, an intervening incident happened that had a huge impact on the business. Say, well, okay, you know what, purchase price is changing, payment terms are changing, a bunch of stuff is changing. So it doesn't make sense to try and have a 1-page amendment. We still want to work something out, we'll replace the old LOI. But if all you're doing is extending the period of time to negotiate a purchase agreement, that's probably a 1-page amendment.
So if the ground has shifted, it's a good idea to look again at, as you say, the difficult questions.
Yes.
Fantastic. Well, thank you very much to both of you for joining us. Thank you to Kaiser Municipal for hosting this webinar. Thank you to all our attendees. This recording will be posted on our website in the coming days. Teddy, do you have any closing remarks?
We just wish to thank you for this opportunity. We've enjoyed it.
Absolutely enjoyed it. We know, listen, everybody's time is valuable. We appreciate you taking some time to spend it with us.